Konig, 1 CPC-25-373. Dr. Konig is present in court and represented by Thomas Otake, and the State of Hawaii is present and represented by Deputy Prosecuting Attorneys Joel Garner and Franklin Pucaro. Gentlemen, good morning to all of you.
Morning.
Good morning, Your Honor.
All of you can be seated. Jury is outside of the courtroom. Mr. Otake, you wanted to take up some matters before the jury came back.
Yes, Your Honor. There's two matters. One is more pressing than the other because it involves Mr. Iinuma, who I believe the state is calling first, perhaps?
Third today.
Oh, okay. Well, even then we
Still today.
Okay, then even better because we might have more time. But I want to at least front this issue for everyone. And I emailed Mr. Garner about it over the weekend. As I was preparing for it, there's been hundreds, if not thousands of pages of discovery turned over in this case, medical records, and Mr. Inuma's discovery was there was a lot. And so as I was going through it again, one of the issues that was raised by Mr. Garner in motions in limine came up, and I believe that there may have been a 404B notice about it, but the issue about the audio recording device, that allegedly
The search for an audio recording device.
Well, during a computer search, pursuant to a search warrant, Mr. Iinuma pulled information showing Dr. Konig at some point, I believe in December, ordered an audio recording device. Obviously we have an explanation for that and if he testifies, he will explain. But as I was looking over it this weekend, it occurred to me, and I understand this probably ideally would have been raised more in a motion to suppress, but it's just something that I didn't recognize until this weekend. And I'm talking about Exhibit 107, Your Honor. States 107.
Let me catch up with you.
Yeah, States 107.
Okay.
So 107, when I was looking at it, when you look at the front page and you look at the second page, there's highlighted words that says recorder. And, then in other exhibits that he pulled, there's highlighted words that typically would reference the applicable terms in the search warrant. So then I went back to look at the search warrant, and the words, and this now, Your Honor, I'm referencing States Exhibit 53 and page 2, but the applicable or authorized search words.
Wait, hang on, Mr. Otake.
I apologize.
I'm trying to catch up with you. States Exhibit.
I believe it's 53.
That's a photograph from this copy.
Excuse me. I'm sorry, Defense Exhibit 53.
Okay.
Yeah.
Wait.
The second page of it.
Okay, I'm with you now.
So, paragraph, for the following property, paragraph 2, the terms that were authorized to look for and pull documents related to off of the computer. The only terms were hike, poly, puka trail, oahu, trip, danger, death, fall, slip, accident, climb, cliff, kill, die, WhatsApp, Arielle, Jeffrey, Miller, terror power, protingent, affair, cheat, infidelity, syringe, vile, undetectable, incapacitate, divorce, separate. And those were the terms. So as I was looking at it this weekend, and looking at 107, nothing in 107, references any of those terms. So I believe that this was illegally obtained and should not be allowed to be used in the trial. Thankfully, I don't believe it was mentioned during opening. And at the very least, I think we need a 104 hearing of Mr. Iinuma. I emailed the prosecutor about it, and he didn't really explain much other than to say that the, highlighted shows what the search term was that came of it. But
So just to frame the issue down to its brass tacks, so to speak, your objection to States Exhibit 107 was obtained via search beyond the scope of the search warrant that is Defendant's 53.
correct. And again, I apologize, it's something obviously should have been raised earlier, but in the hundreds of pages of discovery, it's been discovered now, and I don't think that means that illegally obtained evidence should therefore be allowed in if we can stop it. So we have an opportunity to stop it. And again, I mean, that's why I emailed the prosecutor to inquire about it. His response, I didn't quite understand.
Well, let me hear from Mr. Gordon.
Yeah.
Mr. Gordon?
Okay, the only digital forensics materials the state is in possession of are those that are responsive to the search warrant and those search terms that Mr. Otake read out. So what we have here is maybe a disconnect, and maybe I didn't explain it very well to Mr. Otake in my email response. What was provided as a result of the search warrant was a folder from the digital forensics detective, with a software called the Magnet Axiom Examine. That software contained the digital forensics materials that were responsive to the search warrant. And each artifact, the digital materials that was in that software, that was cataloged, had a color-coded tag next to it that showed which term from the search warrant matched part of that artifact. So which term from the search warrant basically flagged that artifact to be included. The term with regards to this artifact is separate.
Is what?
Separate.
And I'm sorry, did you reference one of these record numbers on this? What number was it? In the Magnet report? Or?
I don't think I referenced it
Oh, okay.
in the Magnet report. This is in the actual software that was provided in Discovery.
This thing, right?
No, this is the actual software.
Okay.
So,
Sorry, go ahead. I didn't mean to interrupt. I'm just trying to follow along.
I need to talk out loud so I can understand it. What you're telling me is when Detective Inuma executed the search warrant, or the search pursuant to the search warrant, part of the results for the word separate, it pulled up State's Exhibit 107.
It did pull up State's Exhibit 107. It pulled it up in the code underlying that exhibit. So in the actual, so State's Exhibit 107 is the email indicating that this package from Walmart arrived. If you go to page 2 of State's 107, that's where the word recorder is highlighted. The reason that is highlighted is that's because in that same software that only had the contents of the search warrant, that's what was typed into the search bar to go back and find this artifact. It's not an indication of what was flagged by the search warrant. If that makes any sort of sense. And if,
I'm trying to make the connection. So run that by me again.
Sure. When a user is using the Magnet Axiom software, which I actually have up on my screen now, I don't know if it would be easier for me to find an HDMI and plug it into the screen up there to do this, but I'll try and explain first.
Please.
So I have a list of all 7,941 artifacts that were responsive to the search warrant. In the top right is a search bar where I can search for any term I want, but the only results are going to be those, the only artifacts I have at all are the ones that are responsive to the search warrant.
I see. So what you're telling me is recorder, that's highlighted in here, is a manual search by Detective Inuma of materials that were already called out by the program from the search warrant.
In this case, the word recorder was me, since the state has to prepare the exhibits, but yes.
Okay. So, and part of my disconnect here is I don't fully understand the operational mechanism of the program that's being used.
Sure.
So is it, you tell me, Mr. Garner.
Sure.
Why would the search term separate in the program pull up this email from Walmart?
Detective Inuma would probably be able to determine it better, but it was contained somewhere in the underlying code that's related to that email.
Okay.
Good. So the term is in there. If I look at the screen, which I'm looking at, there is, very, very long kind of code that I don't think would be helpful to anybody that's not an expert in understanding this.
Okay, so I have a better understanding of why recorder is highlighted. Go ahead, Mr. Otake.
So, but, I mean, how a software operates is one thing. Like you said, the operational mechanism of this software that law enforcement uses is one thing. That's frankly irrelevant. What is relevant is what the search warrant allows.
Mhm.
And under paragraph 2, what it allows is electronic files and data stored within a specific electronic device and storage media. But this is the important part. But specifically to seize only files and data that contain, include, reflect, or otherwise reference the following terms. So, just because you use some whatever law enforcement software and you type the word separate into your law enforcement software and it pulls up files that do not contain that term, that violates the search warrant, because the search warrant says you can only seize files and data that contain, so this file does not contain the word separate, include, this file, when I'm saying this file, I'm talking about 107, does not include the word separate, reflect, this file does not reflect the word separate, or otherwise reference, this file does not otherwise reference the word separate. So, that's why every other exhibit, I mean, as far as I could see, the exhibits they're planning to use, it has the terms in it. Hike, Polypuka, Miller, Arielle, infidelity, divorce, right? So those, all of those, contain, include, reflect, or reference the search terms. This file does not. So it doesn't matter for purposes of compliance with the search warrant if some software somehow, for whatever reason, pulls this up. And again, I still quite don't understand why the word recorder is highlighted. I mean, because it sounds like the prosecutor did that, and in the other ones, the search terms, I believe, are highlighted. So that's what made me look at it, and I thought, oh, is recorder a search term? And then it's not, right? So what matters is, does this file contain, include, reflect, or otherwise reference the term separate? And it does not. It does not. So it was obtained illegally, it was seized illegally, and it should be precluded.
I think we should hear from Detective Inuma.
And that's what I started off by suggesting, that we may need a 104 hearing.
Because
And that's why I asked about timing.
We assume, or right now, the argument assumes that the file doesn't reference separate.
I mean, just by looking at it, what's been turned over doesn't.
Well, there's more to that in an algorithmic search, is what I'm thinking, because it might, depending on what the algorithm is, still refer to separate. We don't know how the software operates, right?
Well, I agree with that, but again, I don't think within the definition of contain, include, reflect, or reference, some whatever, I don't know much about tech, but just if it's like, they're talking about seized files that contain, include, reflect, or otherwise reference. So if there's some like underlying whatever I don't even know what it's called, metadata or whatever, that's not this. So this this is a file that was obtained.
I think your argument is right on point, Mr. Otake. If the search warrant just contained the words contain, include the following key specific terms. But because we don't really understand what reflect or otherwise reference, I'm happy to hear from Detective Inuma further.
Yeah, and I appreciate that. And again, I would like to as well, because that's anyway.
So
And it's good because he's later today, so.
Mr. Grant?
Sure. I do want to put, just so everybody knows, the word separate was contained in not the exhibit that was prepared, but it was contained in the underlying data that has been provided. So I expect that's what Detective Inuma's, I guess, testimony at this hearing will be.
Okay. And do you actually have that separate data that reflects the email?
I mean, I'm looking at it right now on my screen.
Can I see it?
Yeah. Show Mr. Otake.
This is actually a different email, but same idea.
Okay. Well, I'd like, when you're ready, when you have the actual one we're talking about, let me know. Thank you.
So can I table that aside for now?
I think so, if we're not calling him now.
Yeah, if you're satisfied by what is viewable on the program, then maybe the issue resolves itself. And if not, we can always hear from Detective Lee a little more further.
Pretty sure I'm not gonna be satisfied, but I'll take a look.
We're always
Thank-
hopeful, Mr. Otake.
Yeah, I know. And thank you, Your Honor. Again, I admit this is something that should have been raised earlier, so I apologize for that, but
So if we have to have a 104 hearing, this is what I
I
suggest.
think it'd be short.
Maybe.
Yeah.
Let's see where we are, because we have other two witnesses that can go first. Let's
Correct.
take care of those witnesses, and then we'll have the 104 hearing before Detective Inoma really testifies. And depending where we are in the day, we may just do the 104 hearing, or if we can do it in a short amount of time, then maybe we can call him as a witness.
Understood, because I think we're gonna have plenty of time on Tuesday as well if we need it. Thank you.
So that's one issue. You had something else, Mr. Otake?
Yeah, the only other issue, and I think it's easily remedied, but, so, if the court recalls, their motions in limine, there was the issue of, in response to us raising the issue of Ms. Konig removing roughly $123,000 from a joint bank account 3 days after the alleged incident. In response to that, the prosecutors interviewed her, and she and email reference after the $123,000 was moved, they say that there was a few transactions where smaller amounts of money, you know, maybe like $800, $1,200, I don't know. There was a few transactions where money was then removed from their account without them authorizing it, and the inference was that it was Dr. Konig who did that. We fought that in motion in limine because obviously he was in OCCC, and obviously you don't get to do online banking in OCCC. But the court allowed that in, which is fine. But the issue is this: on our witness list is Dr. Konig's brother, Ruan Konig, who resides on the mainland. And he's the one that followed up on this, communicated with the bank, and had to take steps to shut down the account when he learned it was those transactions were fraudulent, related to some address in Texas that set up fraudulently accessed those accounts and moved the money. And he has knowledge about that it wasn't Dr. Konig. So I thought that Mr. Garner might get into that with Ms. Konig. So we have Ruan on standby, but he lives on the mainland. He did not. So I emailed him over the weekend and asked him, okay, you didn't get into that with Ms. Konig. Are you planning to cross Dr. Konig about that, or get into it with Emil? Because I only ask because if you are, then we're going to need to call Ruan. And, ideally we would call him Tuesday afternoon, but it was just logistically trying to not fly him here for no reason if they're not going to get into it. But we can't wait to find out because it's going to be, timing-wise, it's going to lead to a delay. So I asked if he was going to get into it. Mr. Gardner essentially said that he can't tell me because it depends on, I guess, what he said is it depends on how Dr. Konig testifies, right? So the solution that I guess I've like to propose is that if he gets into it, that we be allowed to call Ruan by Zoom.
Mr. Gardner?
That's fine.
Granted.
Thank you. That was it.
Anything else we should take up while we wait for the jury?
No, we'll wait for the jury. I can show Mr. Otake. I picked up the artifact.
Okay, so are we, we're going with Amarin?
Okay, let's go.
Oh, sorry.
Off
Off record.
record.
Yes, yes.
And